Hola y bienvenidos de nuevo a nuestra serie de análisis jurídicos. Hoy profundizaremos en un tema crucial but often overlooked aspect of family law, guardianship, or as it's known in Venezuelan law, tutela specifically. We'll explore what happens after a guardian is appointed. What are the excuses for not taking on this role? What are the initial steps a guardian must take? And what safeguards are in place to protect the minor? Let's get started. First, let's talk about getting out of the job. While the Civil Code is very clear about excuses for guardians, what about the members of the Guardianship Council? Interestingly, the law isn't as direct. However, it does grant a judge the power to excuse someone from being a council member, or even from attending meetings, for valid reasons like living too far away. The judge makes this call without a complicated process. For guardians themselves, if you have a valid reason not to serve, you must present your excuse to the judge within 3 days of being notified of your appointment. If you're not in town, you get extra time for travel. For a legal guardian, like a grandparent, the clock starts ticking once they learn about the situation that requires their service. The judge will then review the reason, appoint an interim guardian, and consult the Guardianship Council. If the judge accepts the excuse, you're off the hook. If not, you can appeal, but that's the end of the line. But what if someone just refuses to do their duty? The Civil Code doesn't take this lightly. There are financial penalties, like fines, for guardians, pro-guardians, and council members who neglect their responsibilities. More seriously, failing to assume the role can be grounds for removal, along with liability for any damages caused to the minor. Now, let's assume a guardian has been appointed and has accepted the role. Can they just jump right in? Not quite. The law requires several important formalities to be completed before the guardian can fully exercise their functions. These apply specifically to the guardian, not the pro-guardian or the council members who can start their duties immediately. The very first formality is ensuring a pro-guardian is in place. Think of the pro-guardian as a built-in check and balance. Their job is to represent the minor's interests, especially if they conflict with the guardians, and to keep a watchful eye on the guardian's conduct. This role is so vital that it's a matter of public order. A guardian cannot start their duties without one. Even parents can't waive this requirement in a will. If a pro-guardian hasn't been named by the parents or the judge, the guardian themselves must immediately push for their appointment. Failing to do so can lead to serious consequences, including financial liability for any resulting damages and even removal from the guardianship. The next critical step is creating a detailed inventory of the minor's assets. This is non-negotiable and must be done for every guardianship. Why is this so important? First, it helps determine the amount of the security bond the guardian must provide. It also establishes a baseline for the guardian's financial responsibility and makes it easier to track whether they've properly managed and returned the minor's property when the guardianship ends. So, who creates this inventory? It's a team effort involving the guardian, the pro-guardian, and the members of the guardianship council. The judge doesn't need to be present. The guardian must begin this process within 10 days of being notified of their appointment. The inventory itself must be completed within 30 days, although the judge can grant an extension if circumstances require it. What goes into this inventory? Absolutely everything. It must list all assets and liabilities of the minor. This includes movable property like furniture, specifying its estimated value, and immovable property like real estate, describing its condition and approximate value. It must also list all debts, credits, and any relevant documents. The law is particularly strict about one thing. If the guardian has any personal claims or debts against the minor, they must be included in the inventory. Hiding this is grounds for immediate removal. Once completed, the inventory is filed with the court, and everyone involved must swear an oath that it was done accurately. Any omissions or errors can make the responsible parties personally and collectively liable for any damages caused to the minor, in addition to fines and potential removal. After the inventory is complete, the guardian, unless they are a grandparent, must provide a security deposit, known as a caution. This is a guarantee to cover the results of their administration of the minor's assets. The judge determines the amount of this security. The guardian can choose between a personal guarantee or a real one, like a mortgage. If they don't choose, the guardianship council will identify property belonging to the guardian on which a legal mortgage will be placed. If the guardian doesn't have sufficient assets, a new guardian will be appointed. This mortgage is registered and serves as a financial safeguard for the minor. During the guardianship, the judge can increase this security if needed, and may allow the guardian to substitute one form of security for another, as long as it doesn't harm the minor's interests. Failure to provide this security is, again, grounds for removal and liability for damages. The final formality is called discernimiento, or the formal authorization of the position. This is a judicial decree issued by the court that officially authorizes the person to act as the guardian. It serves as proof that all legal requirements have been met and that the guardian is empowered to represent the minor. This is mandatory for all guardians except grandparents. This decree must be officially registered and then published in the press. The court is responsible for ensuring these steps are followed and can impose fines for non-compliance. This document is what the guardian will use to prove their legal standing when dealing with third parties. So, what happens while all these formalities are being sorted out? The process can take time, and the minor needs care and their affairs managed in the meantime. To address this, the law provides for the appointment of an interim guardian. The judge can appoint someone, preferably a relative or family friend, to handle the minor's immediate needs. The interim guardian's role is limited to day-to-day care and essential administrative tasks. They can only perform acts that go beyond simple administration if there is an urgent need and they have special authorization from the judge. After consulting the guardianship council, The interim guardian is not required to complete all the formalities we discussed, given their temporary role. Their appointment ends as soon as the permanent guardian is fully authorized and ready to take over. An interim guardian might also be appointed if a permanent guardian is facing a removal proceeding, and that is a comprehensive look at the crucial steps and safeguards involved in establishing a guardianship after the initial appointment. These formalities, from the pro-guardian and inventory to the security bond and final authorization, are all designed with one primary goal: to protect the well-being and the patrimony of the minor. They create a system of transparency and accountability for one of the most important responsibilities a person can undertake. Thank you for joining us today. We hope this explanation has been clear and helpful. If you found this video informative, please give it a thumbs up, subscribe to our channel, and hit the notification bell so you don't miss our next legal deep dive. See you next time.